Hello, my name's Nadine Tilbury. I'm the Policy Officer for the Working Together with Parents Network. I am a non-practicing solicitor. I have a background in local authority. I was a local authority solicitor once, so I feel their pain in many of the comments I make about parents with learning disabilities and them ending up in court. I was in private practice, litigation, civil and family, and I was a civil servant working across the family justice sector and the criminal justice sector, in particular insofar as the interface between the two and where there were disabled witnesses and victims or child witnesses and victims. The Working Together with Parents Network is UK-wide, based at Bristol University. We have over 1,030 members, all from social care, adults, children, health, legal, independent advocacy sectors. They're all professionals working in one way or another with parents with learning disability. We have a regional directory of services available that are particularly relevant to parents with learning disabilities. But the network's whole starting point is about the child's welfare is paramount. And our aim is about fair processes. It's about respecting the family's legal rights. It is not about this child must remain with its family at all costs. Fairness. This is something that a fair trial is a fairly familiar concept granted by Article 6, but it is not confined to what's called the purely judicial part of the proceedings. The proceedings, in fact, begin the moment the state, in this case the local authority, becomes involved with a family. And so fairness has absolutely got to start from day one of the state's involvement with the family. Talking about parents with a learning disability or a learning difficulty, or indeed a cognitive impairment or an intellectual disability, people get very confused and worried about using the wrong expression. But if we look generally, as far as the network is concerned, we tend to talk about learning difficulties because that for us includes parents with a diagnosed learning disability, but also those with a milder impairment who struggle with the same issues: literacy, numeracy, abstract concepts, time, organisation, planning, etc. But if they don't have a formal diagnosis, they tend not to be eligible for services and support. The parents we work with tend to have a preference for learning difficulty because they say if people say they have a disability, it means they can't learn, whereas they can learn, but with some difficulty. So again, depending who our audience is, as a network, we tend to use the vocabulary that is the preferred one. The Department of Health's definition goes way back to 2001, valuing people, and that's based on learning disability being indicating the presence of a significantly reduced ability to understand new or complex information, to learn new skills. It's what they call impaired intelligence. Also a reduced ability to cope independently, which is impaired social functioning. And it has to start before adulthood with a lasting effect on development. What is the relevance of an IQ level? We see all the time reference to the IQ of the parent having a reference above or below 70. Well, there's no magic number. And depending whether you carry out the IQ test in the morning at 10 o'clock or in the afternoon at 2 o'clock, the readings could be very different. You could have a 74 and you could have a 65. It is very fluid, the IQ level. An IQ level reading is not a predictor of parenting ability. It is not an assessment of parenting ability. It is not evidence of parenting ability. What it is an indicator of learning and retention and the application of knowledge and skills. That's to say how that particular person is likely to learn and likely to remember things so that they can use their skills and knowledge. That's all. But one of the important aspects about the IQ level magic number 70 is that it can be the gateway to eligibility for services and support. So to that extent, it's important. But we very much like the CARE Act that refers to a reliance on an appearance of need rather than any formal diagnosis. If you've got a person, a parent who appears before you, whatever professional capacity you're working, If the parent presents as struggling with issues of literacy, numeracy, abstract concepts, time, organisation and planning, etc., and children's services have got some kind of concerns about their parenting, this would surely seem to indicate an appearance of need. The eligibility criteria under the Care Act includes being unable to achieve 2 or more of the non-exhaustive list of 10 outcomes. And one of those outcomes includes carrying out any caring responsibilities the adult has for a child. Now, the other 9 outcomes, it's almost impossible for a parent with learning disabilities not to be able to say that they are unable to achieve. For example, it's fine if a single adult on their own has a suboptimal house in terms of cleanliness and maintenance of hygiene, and their food input is not of the healthiest. But once we're talking about a parent, their ability to keep a clean, hygienic, well-maintained house, their ability to use public services to get to clinics and appointments, that becomes relevant. So it is really quite difficult not to be able to say that you meet the eligibility criteria under the Care Act once you have got children's services involved and their concerns are based on these type of issues, literacy, numeracy, abstract concepts, etc. Now, care proceedings, there's a general common theme that runs through care proceedings and parents and difficulties that they face. But when you're looking at parents with a learning disability, there are particular issues of relevance for them. As you can see, timeliness, advocacy support, assessments, joint working, Care Act, long-term mindset, assumptions, substitute parenting. I'm just going to talk about some of those very briefly as an introduction, really, to the issues, but hopefully to raise awareness of the fact that those are the issues that are relevant. Time is the biggest problem. There's a countdown with a very loudly clicking clock, even a ticking clock for the parents. There's a child's timetable, there's the court's timetable, there's the parents' timescales for learning and applying new skills. There's the timing of the assessments, which we've already discussed. All of this, very, very important for the parents. And every wasted day or week or month is unlikely to be recoverable. There's stages. There's the intervening before birth. There's the period before pre-proceedings. There's the child in need stage. There's the child protection stage. We're then in the pre-proceedings formal stage. We're then in maybe in the court stage. We're then perhaps in temporary removal under an interim care order stage. What is happening? What work is being carried out at each of those stages? Because as I say, time lost is rarely recovered. Looking at advocacy support, for example, local authorities often refer to statutory advocacy as a reason for not being able to provide an independent advocate to help the parent effectively communicate. But when they talk about statutory advocacy, they're referring to the Mental Capacity Act, the Mental Health Act, and the Care Act. They don't seem to be referring to the statutes of the Equality Act and the Human Rights Act. And very often there's a fight over whose piggy bank should pay for the advocate. Should it be children's services? Should it be adult services? They were very pleased when a couple of court cases came out saying that there was also scope for the legal aid to pay and the HMCTS, depending on the stage proceedings had reached. But advocacy support can be essential for ensuring two-way effective communication with a parent with learning disabilities. Joint working, adult services. There's a duty to cooperate under the Care Act, Section 6. A duty. I mean, who knew? This is something that really isn't referred to sufficiently, although the Ombudsman has done his best in several cases. And Sky, in a national review of serious cases, also identified an egregious lack of joint working together between adult and children's services. The long-term mindset, this is a funny one. There seems to be an inherent difficulty with the concept that a learning disabled parent may require long-term support. If we were talking about a disabled child or a disabled person, nobody really bats an eyelid. It's clearly going to be something that's long-term. But as soon as you say disabled parent, up comes the reservations about, this will be too long. It won't be sustainable. Care Act. This is something that really any child social worker, any legal practitioner working with children's cases where a parent with learning disabilities is involved should be familiar. We've talked about the appearance of need. There's an eligibility for assessment, eligibility for advocacy, although for very limited purposes, strictly under the Care Act. There are so many things that the Care Act is relevant for a parent with learning disabilities. So practitioners really do need to be familiar with those key concepts. We're going to look at a moment at assumptions and discrimination and assessments. Specialist assessments. There are several frameworks available: PAMS, Parent Assess, QBAS, learning curves, etc. But the effectiveness and the fairness of the process completely depends on how that framework has been used. It's essential to understand how the framework was designed to be used, especially those that are heavily algorithm-based. For example, let's look at PAMS. Its intended use is to identify the strengths and needs, to identify training or support needed, and put that in place, and then reassess to see if the learning has been achieved. The actual use often tends to be simply an identification of the deficits. There's practically always an insufficient scrutiny or challenge by the legal professionals, mostly due to a lack of competence or understanding of the complex charts and reports that are produced by PAMS. Prejudicial, discriminatory practices experienced by parents with learning disabilities. There are often assumptions and low expectations from the outset. It starts from a point of, they'll never manage, as opposed to a Bob the Builder approach, yes, we can. Often, steps in the process are skipped because, after all, the outcome is inevitable. So why spend time and money that will basically be wasted? Parents' views and opinions are often not respected or taken seriously. Now, this often, I think, applies to new mothers generally. When a new mother says they know, they feel there's something wrong with their baby, they're often dismissed as being over-neurotic, overly worried as a new parent. Well, our parents with learning disabilities often get this. And they are often, like your new mums, they're often vindicated. When they say, I felt there was something different, there was something not right, often they are right. There wasn't something right with the child. But as I say, because they have a learning disability, there's an assumption made often that their view and opinion isn't valid. Higher standards are often required. We have several times seen evidence where a child is running around the room and, with parents who have not got any visible disability of any kind, and the parent is not watching that child. The parent doesn't see the child take a tumble. Any other adult will pick up that child that's taken a tumble, and nobody bats an eyelid. But I've also been present with a parent with learning disability who, with the child on her lap, bent down and knocked the child very lightly against a table. The room went silent and all eyes turned in her direction. There was a very definite difference in how the parents in the room treated a learning disabled parent and a non-learning disabled parent. Differentiation between physically disabled and learning disabled. Again, this is slightly odd. A case we had where a wheelchair-using mother who was not weight-bearing herself had 24/7 carers team for herself. They happened to look after the child once she'd had the child. because the mother couldn't physically lift the child on and off her lap, for example, and all was working fine with this very intensive support system until the children's services had a concern that maybe the mother had some form of learning disability. And within 2 weeks, proceedings were started for an interim care order on the basis that a support package would be too intensive, too costly, too long-term, too substituted parenting. Nothing had changed on the ground apart from the perception of the particular children's services involved. And the potential for long-term need for support, we've already mentioned. Children's social workers, they need confidence in their ability to work effectively with families impacted by parents with learning disability. They need the skills and the knowledge to do so, or to be able to access their colleagues who can do so in adult services and local learning disability teams. They need management support. They need provision of training and information. There's an absence of relevant information in the current statutory guidance Working Together to Safeguard Children 2023, just as there was in the previous version and the previous version, but in stark contrast to the 2010 version, which had 6 pages about how to work with parents with learning disabilities. Now, all there is a hyperlink on the last page of the statutory guidance. A hyperlink leads to the good practice guidance, which at least is something, but that's all there is. This is a specialist, although far from niche, area of work, and it needs to be recognised as such. Very recently published research by Professor Katie Birch and her colleagues indicated that 1/3 of the 200 recently completed care cases they looked at across 4 local authorities involved parents with learning disabilities. So really, the local authority children's service social worker really does need to have an understanding of how learning disability impacts on the particular family they're working with. People often ask about the children of parents with learning disability. Well, the children's studies, there's no consensus about the children's development. Children are often very accepting of parental limitations when support is provided from elsewhere. They're often very protective or defensive of parents. They are hugely angered by what they see as lack of respect shown to their parent. And of course, they fear removal. Now, how can professionals support a child properly if they don't understand how a parent's learning disability affects their ability to parent? Katie is a young woman now who we worked with, started some years ago when she just turned 18. She doesn't have a learning disability. All her siblings do, and her parents do. She, therefore, at school didn't have an assistant. She didn't have any special needs. She didn't have any special treatment. But as she says, if my teachers had understood what my home life was, I would have done much better at school. And this, I think, also applies to children's social workers. If a children's social worker doesn't understand how the child is experiencing their life, I don't really see how the children's social worker can do their best for that child. And children are quite flexible in alternative arrangements. For example, Katie, she had her first sleepover with her busy friend down the road. And that was the first time she realized, when she was about 13 or 14, that other people's families weren't like hers. And it was that busy friend's mum, who actually was a social worker, who took over helping the parents to understand Katie's school needs. She used to turn up to every parent's evening, and they would ask if Katie was on time, if she behaved well. They had no idea what the curriculum was or what her options might be. Why would they? So a bit of lateral thinking around the child's world, other than in the very narrow context of immediate home life, is often quite valuable for the child, expanding its horizons, providing other options where the parent can't provide them, for example, help with homework, can really, really broaden the child's life. Another rather overlooked cohort here, fathers. and fathers with LD in particular. As one of them said to us, what am I, a spare part? They were constantly overlooked at health appointments, social worker meetings. They were just ignored. And sometimes the fathers turned out in the end to be the primary carer. So there hasn't been a lot of research, but there has been some specific research about dads. Some of the resources are on our website, and there are increasingly more studies looking at fathers' roles. Turning now to the good practice guidance on working with parents with a learning disability, the latest version is 2021. It first came out in 2007, was refreshed in 2016. Now, ultimately, if the principles of the good practice guidance are applied by any professional working with parents with learning disabilities, they will be complying with the requirements of the Human Rights Act, the Equality Act, the United Nations Conventions on the Rights of Disabled People, and the United Nations Convention on the Rights of the Child. It's all rights-based and very simple, very straightforward. As one of the presidents of the Family Division said, it's not rocket science, it's all there in one document. There are 5 key main principles: accessible information and communication, clear and coordinated referral and assessment procedures and processes, support designed to meet the needs of the parents and children based on assessment of their needs and strengths, long-term support where necessary, and access to independent advocacy. In 2018, the President commended the good practice guidance. In 2022, Mrs. Justice Knowles in the High Court at paras 106 onwards referred specifically to the need to apply the good practice guidance principles and to demonstrate to the court that those principles had indeed been applied. There's quite a bit of information on this slide, so I'll just give you a moment to read through it. In 2023, Sir Andrew McFarlane, he who referred to it ain't rocket science, he said, detailed knowledge of the guidance, coupled with a continuous awareness of the need to be alert to the issue of intellectual impairment, should enable one and all, be they judges, magistrates, or social work professionals, to meet the needs of the children in these important cases. And I was really pleased that he focused on the children, because that, after all, is very much the point. By supporting the parents to parent well, the needs of the children are being met. And in conclusion, mindsets from the outset, from day one of an involvement with the parents with learning disabilities, will inevitably affect the fairness of the process. And whatever the eventual outcome for a family, whether the child stays or has to go, the parents and children deserve and are entitled in law to a fair process. Thank you.